From Morris Succession Lawyers, and just wanted to have a quick discussion today about mutual will or contracts to make mutual wills. It's something where sometimes you get, in an estate planning sense, you have a husband and wife typically involved in a second or later relationship, and they can enter into a contract whereby they agree to not revoke or change their wills down the track or give away parts of their estate once the other has passed away. And they could do it before either of them has passed away, but only with their agreement and consent. There are variations on the mechanics of those, but typically that's the sort of arrangement that you would see. And there's something that has to be used with caution, but it's something that we also come across a lot of, having taken over a previous firm which had a long history of preparing estate planning documents over many decades, and it was a tool that they had used in the past. So that's something that we see come up with some of our clients. And we had a case recently involving a mutual will contract which sort of showed some of the difficulties. It wasn't one that we'd actually done. We were acting for the surviving spouse, and the surviving spouse had found out after the person passed away that the testator or their partner had actually breached that contract and entered into or gone and executed a new will. Unbeknownst to our client, that person had gone and done the will. They had left the majority of their estate, or all of their estate effectively, to some of their children from a previous marriage, which left our client in a difficult situation. Now, that in itself evidences one of the main problems with a contract to make mutual wills. It is just a contract. It doesn't preclude a person from actually going out and making a new will. The person can do that. It's just a breach of the contract. So that entitled our client to therefore sue for the breach of contract and seek to enforce the terms of that agreement, which is basically creating a constructive trust around the assets that were gifted away. So the executor of the later will still manages the estate, but they hold it on trust for the beneficiaries of the contractual will. So these cases go back a long way. The first case involved, or the first authority for it, involved just an oral contract. So a husband and wife made mirror wills that had provisions that mirrored each other, but at the time they had an agreement orally that they wouldn't change the will without the other's consent, and that was upheld. Obviously there would have been evidence issues and with proving that, but most of the time we see them arise is with an actual, either a separate contract or there's a clause within the wills that says this is part of an agreement between the parties whereby they won't change the will down the track. The breach of contract aspect, that's something that's problematic. The other part of it is the giving away during the person's lifetime. The case that we had involved a person, not only did they breach the contract by making a new will, during their lifetime, the last sort of couple of years of their life, they set about trying to give away as much as they could of their own personal estate to their own children, which was circumventing the terms of that mutual will contract. So that's the other main problem with them, is that although you can have this agreement and you can have an agreement not to make a will or not to give away your assets, people still might go and do that, which gives you less security, whereas we would typically look at a trust arrangement as possibly being more fit for purpose. Not every client wants more trusts. There's a bit of trust fatigue. I know some of the council or people working at the bar in New South Wales are also a bit sick of trusts, but they do serve a purpose. You can have a trust arrangement whereby one spouse gives their assets into a trust for their surviving spouse, and that surviving spouse only receives income. They can't get their hands on the capital, and that way, or they might have the use of a house or use of assets. That gives them all the benefits of owning the properties or owning the assets themselves, but also retains the security for those children of the deceased to know that they will still eventually get those assets down the track. Whereas a mutual will contract, it's just a contract. It doesn't give that level of security, and it doesn't always work. And although we were able to successfully pursue the deceased estate for the breach of that mutual will contract, it was a compromise. It did involve the stress and anxiety and cost of legal proceedings, and all of that could have been avoided with a form of trust will. So that's essentially what I was going to talk about today. I know it's been a little while since my last video. End of financial year, a lot happening, a lot of work on at the moment, but I promise I'll get back to putting on regular little snippets in the wills and estates area of law. Also going to be presenting to a conference for people working in the aged care sector up in Queensland in September, and also just out and about in a few local publications as well, so keep your eye out for that. And if you have any questions on wills and estates, if you are an advisor and you just want to pick my brain on some sort of issue that you might have with one of your clients, always happy to take a call, always happy to take an email. Calls are generally better, and I'll help out where I can. So if you do have any inquiries or have any questions about anything to do with succession, then please feel free to give myself or the team a call at Morris Succession Lawyers.